In the previous video, we have already discussed regarding substantive ultravirus, and in this video, we will discuss about procedural ultravirus. And procedural ultravirus means those delegated legislation without complying the procedural requirement prescribed in the Enabling and Parent Act would be declared as ultravirus or void, and these procedural ultravirus are of two types. One is mandatory requirements, and the second one is directory requirements. And in the very leading case, Govind Lal versus Agricultural Product Market Committee in 1976, their lordship expressed that if the provision for prior publication is mandatory, the non-compliance therewith will render the delegated legislation invalid. And in the leading case, Raja Buland Sugar Company versus Rampur Municipality in 1965, their lordship held that if the very publication of the delegated legislation is directory, non-compliance will not render the delegated legislation invalid, provided there is substantial compliance with the delegated legislation's provisions relating to prior publication. And regarding that, the very publication of the draft as per the Enabling and Parent Act was that the draft rule must be published in a Hindu Delhi. Instead, it was published in an Urdu Delhi, and their lordship held that there is substantial compliance as it was published in a Delhi, whether it is Hindi or maybe Urdu Delhi. So, the very delegated legislation could not be declared as invalid or ultravirus. So, the very procedural requirements in an enabling or parent act could be either previous publication, and the second one post-natal publication, and the third one consultation with affected persons. So regarding the first one, that is antecedent publicity or previous publication. So, in the Enabling and Parent Acts, as such, Section 35 of the Contract Labor Regulation and Abolition Act 1970 and Section 15 of Central Tea Board Act 1949, Section 43 of the Cooperative Societies Act 1912 provides the previous publication or antecedent publication of all the delegated legislations made under this Enabling and Parent Act, and also the very Section 23 of General Clauses Act 1897 provides that those delegated legislations, the very draft rule made by the executive or the administrative authorities as under the enabling act, the draft rule must be published in the official gazette. Secondly, objections and suggestions from the public must be compiled. And the third one, there must be a consideration of all such objections and suggestions by the authority concerned, and if all these would be fulfilled, then it would be considered as previous publication or antecedent publicity as provided under the Enabling and Parent Act, and such delegated legislation would not be declared as procedural ultra vires. And in the same way, Section 4 of the Federal Administrative Procedure Act 1946 of United States of America provides for antecedent publicity or previous publication of such acts